This is Green Street, the Environmental Health Show, greenstreetnews.org, Patty and Doug Wood, and our worldwide network of experts here every week to keep you up to date on what we're learning about things in the environment that can be harmful and how you can protect yourself and your family in this increasingly toxic world. Welcome back. You've probably seen the ads. A man with a spray bottle faces down a little dandelion in his sidewalk or driveway. The music is very dramatic, like a showdown at the saloon. And finally, the man squeezes the trigger and the dandelion withers and dies. The message: buy this product and get rid of your weeds. What the message doesn't say is that the product can be hazardous and in fact has been linked to an increased risk of cancer. Does the company have an obligation to warn customers about the dangers associated with the product? Various state agencies say yes, but the company is resisting. They don't want to put a warning label on their product, and last week they went to the Supreme Court to try to get a ruling in their favor. Today on Green Street, we'll talk about that product, the pesticide RoundUp, with an expert who'll talk about the right of consumers to know when a product is harmful.
It was marketed as a miracle product, a weed killer that was so safe you could drink it. And it became the most widely used pesticide in the world. So popular that seed companies used gene splicing to create plants that were resistant to the pesticide, which further increased its use and the popularity of the product around the world. But there was a problem. A lot of people who use the product on a regular basis developed cancer, and laboratory studies showed that indeed the chemical increased the risk of cancer. Last week at the Supreme Court, the manufacturer argued that they had no obligation to warn consumers about the potential harm, and that no state could order them to include a warning on the product's label.
Joining us on Green Street today is our friend Jay Feldman, Executive Director of the nonprofit Beyond Pesticides. Jay's been following this case as it winds its way through the courts, and we started our conversation talking about the origins of this particular case. Here's our conversation with Jay Feldman.
Well, like many other plaintiffs that have sued Monsanto, these are users of the pesticide that they believe to be safe. They followed instructions on the label, and then they got cancer. This guy, Durnell, he was actually a volunteer, and he worked in the local park, managing the park, keeping it tidy, and he used glyphosate. And came to find out that the cancer, the non-Hodgkin's lymphoma that he contracted was or could have been associated with the chemical glyphosate Roundup, which he used. Now, a lot of this stems from, yes, a medical diagnosis that he had the condition, but then linking that cancer to his exposure, that's always a challenge, right?
Yeah, another story altogether, yeah.
Right.
Okay.
So the beauty of being able to sue under failure to warn is that the manufacturer is responsible for disclosing the potential adverse effects, and that had not been done, and it's generally not done.
Right.
We don't see cancer warnings on pesticides. So all he had to really do was show that, yes, he had cancer. He had cancer that was linked to this chemical and that he was not warned. It's very different than strict liability, right? Where you're going in and saying your product caused my cancer. Where
Right.
these lawsuits are saying, I have cancer associated with your product. The science says that this product is cancer causing,
Right.
and you never warned me. There's nothing on the label about cancer. So, it's a really important incentive for the manufacturer to be fully forthright in disclosing what they know about the product. The law, though, goes beyond that. It's what they know or should have known about their product. And in this case, as you know, this chemical was deemed possibly cancer-causing by the International Agency for Research on Cancer. And so that review was really instrumental in telling a jury, and then the jury really accepting the science behind this idea, this claim that this chemical causes cancer. Meanwhile, of course, we have EPA that is dismissing all this science. And it's not just the IARC, International Agency for Research on Cancer. It's not just their review. there's a body of science. The scientific literature is just full with this stuff. In fact, the first classification EPA gave glyphosate being the active ingredient in this formulation called Roundup, was cancer causing. And
Really?
yes, it was originally
Hey.
classified as a carcinogen or possibly carcinogenic,
By the
carcinogen
EPA.
by EPA. And then they put that out for public comment, and Monsanto influenced the agency as it typically does, and they changed the classification to no evidence of cancer. So, over the years, this has been a very controversial issue because it is of moderate acute toxicity. But of course, as you guys know, that has nothing to do with what the chronic effects, long-term effects can be associated with exposure.
Wow. Okay.
So this was a case, the jury awarded $1.25 million in the case against Monsanto. And when you tally up all the cases across the country, thousands, Monsanto is on the hook for over $10 billion in litigation.
Okay, so let me ask you, and you've probably seen it too, but here in the New York area, we're seeing these ads on television saying, if you've been exposed to glyphosate, blah, 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 if you have non-Hodgkin's lymphoma, you can get from $6,000 to what? $160,000, but then you're not eligible
Right.
for.
You forfeit your right
You
to.
forfeit your right. Yeah.
Well, that's part of the settlement process, right? Obviously, all litigants have the opportunity to pursue the litigation to the end, go to jury
Right.
trial, and then, try to really get both compensatory and punitive damages. And, mostly what's happening with these trials is there's a high punitive damage award. But that's really a function of the individual plaintiff, in terms of what they want to do. Usually what these corporations like to do is settle with a class and then have everybody put into that class, and then they don't have to worry about additional litigation.
That limits their exposure, right? And that's what they want. They want some sort of certainty. What is this thing going to cost us? Tell us what it is. We'll pay it, and then we're done.
Right.
We're done, and we're going to still think we're going to keep selling it.
Yeah,
exactly. What I find fascinating about all this, because obviously over the years we've seen litigation against specific chemicals. There's a line in their budget, the chemical companies, where they basically write off all the cases, all the jury awards, all the settlements are just a budget line for them. It's something that is tax deductible for them, literally. And so, it's one of these costs of doing business as they see it. And I think what happened with glyphosate is it gained so much momentum, and the numbers got to be so high that it just became untenable for
that line item was they couldn't really make that work anymore.
Right. So whereas they would have let it go as a line item, write-off, what's happening here is they've basically said, look, this is unsustainable financially for the company. So let's change the law, or let's get a better interpretation of the law so that people cannot any longer go into court and sue us for failure to warn.
Jay, is this going to be retroactive? What about this settlement that's in place that Bayer has already agreed to pay? Will this court decision, if the Supreme Court says, no, you didn't have an obligation to warn, does that award go away? And does that all those cases are moot?
Well, that's a really good point. I think what they're doing is they're appealing in the case of the jury verdicts, right? They're appealing those cases by virtue of this case. This is essentially an appeal to this one individual, but it's basically systemic in that decision is going to affect all the trials that, have been decided. It's basically an appeal. I mean, they're appealing to the Supreme Court to say, these were unfair judgments, misinterpretation of law. I'm not as clear as what happens with a settlement, because I think in that case, they've circumvented the jury system and the court system, and they said, okay, we want this to go away, take our money. I think they're going to have a harder time reversing a settlement. They've signed a settlement. They've agreed to pay. They didn't pursue the whole court review. And so they are obligated by virtue of that contract that they signed with the individual litigant.
In which case, the people who have lawsuits pending, which are likely to get dismissed,
Yes.
might be wise to say, you know what, we might get this thing dismissed. We'll sign up and be part
Well,
of
that's
the
what
settlement, and
That's
at least
that's
we'll get something. But the idea that you're going to get, oh, here's your check for $8,500 for your non-Hodgkin's lymphoma. Sorry, I
yeah,
mean,
that's 1
doesn't
month's treatment
begin
or
doesn't
less.
begin to make up for the enormous costs these people are going to be incurring.
You're right. I mean, this is a situation where, there's ripe for poly market, right? You're
Oh,
betting on
God.
which way the court's going to go on this.
Well, okay,
Wow.
so speaking of which, what was your sense? It wasn't clear, I
Yeah,
understand, to tell
no.
from the arguments.
You know, this is the age-old issue of whether a federal decision, at a federal agency is preemptive of what goes on in the state, at the state level and in state courts. The industry obviously would like to see all the laws that they comply with supersede anything else that happens outside the purview of that federal agency. The problem they have is that FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act, which is the authorizing legislation that empowers EPA to register pesticides and make determinations on health and safety, environmental impacts. That law specifically allows states to adopt standards that are more stringent
Higher.
than the
That's
federal
right.
government. I mean, it's
That's right.
embedded in the law. It's an expressed authority that a state may ban a pesticide, right? The question here, though, is whether the state has the ability to affect the label and demand manufacturers that have already registered their pesticides at the federal level demand that that label reflects a warning that EPA does not require. Now, you can imagine there's a real dissonance here with political philosophy around states' rights and the power of the federal government, and how does federalism operate in a way that's fair to people who have been harmed. And that was in play here. And I think the politics gets reversed. I mean, you see some of the most conservative judges like Thomas, et cetera, really apparently, seemingly siding with the chemical industry. The law really hands the manufacturer the authority to write the label. EPA does not require any labeling for chronic or cancer effects. The labels that do have that on it have occurred because of states that have state laws like California, Prop 65, that require disclosure to this effect. And we know over history that labels are constantly being revised. When a manufacturer knows that they can be sued for an effect that emerges, let's say after they register the product, new science is coming out, as you guys know, all the time.
Yeah.
And that becomes a responsibility of the registrant to say to EPA, this new study came out, we really need to get that on the label. And this creates a very important incentive for the manufacturer to disclose around the registration process, which again is a very time-consuming, drawn-out process. It could be a decade after numerous scientific studies come out that the label, needs to be changed and is not changed. So over the years in our public comments, we actually said, put on the label what you don't know.
Sure.
You're telling people what you do know. You're saying, be careful. Don't breathe this in because it's a respiratory toxicant, or wear a mask because you shouldn't inhale this product, or wear protective clothing because dermal absorption will result in neurological nervous system effect, whatever.
Our current EPA is literally just dismantling anything that they did have that was reasonable and protective, just dismantling it when it comes to protecting public health. It's like, we just want the industry to make money. Take off those regulations. We don't care what's coming out of their smokestacks. Done.
Yeah. You're listening to Green Street, and our guest today is Jay Feldman, Executive Director of Beyond Pesticides. Did the issue of compelled speech come up? I know when we were working on the consumer right to know with regard to cell phones and their ability to cause cancer,
Yeah.
the argument from the industry was, no, you can't compel us to put something on the label that we don't want to put there. Under free speech, under First Amendment, it's compelled speech and we don't have to do it. Did that
Yeah.
argument come up? Did anybody ask about
Not exactly in that context, but essentially they're basically saying that the problem is that the underlying statute here does require them to disclose harm that they're aware of.
Yeah.
Now, the question is, there's a provision in FIFRA 682 that literally says that the manufacturer must disclose to EPA evidence that they have, information that they gather that shows that a product hurt people. And that information is available. I mean, you can get it through the Freedom of Information Act, and we've done this over the years. And you know what? You know, those consumer hotlines, people call in and they
Yeah.
call the manufacturer and say, I got hurt, or this product stained my clothing, or whatever. It took the paint off my car. What's
Right.
up with it?
Right.
You know, that information is supposed to be under federal law reported to EPA. Now, that's one step removed from putting it on the label, but that's where misbranding comes in. So there's a misbranding provision that I would argue compels the manufacturer, and this is what the lawyer for Journal said, you know, you are compelled by virtue of the misbranding clause to disclose on the label this information that you gather or that you should have gathered by virtue of what's available in the scientific literature. Now, of course, Monsanto would argue, we're not compelled at all to do anything unless we're asked by EPA to do it, which defies logic given that they write the label. Monsanto wrote its own glyphosate label, and that's what we're working from. Another thing I found fascinating, having the background in pesticides and following the questioning here and the justification for statements that Monsanto lawyers made, I found fascinating. For instance, they keep bringing up, you'll see in the press and you'll see even in the court documents, this claim that we can't grow food without glyphosate. We will not be able to grow the food we need as a people unless we have access to this chemical. Now, that's a pretty broad statement to make. And it's really a policy issue. It's not really a legal issue, but I think it influences how they think about the impact of their decision as judges.
Yeah.
And so they make this claim, can't grow food without glyphosate.
Yeah.
And then they point to President Trump's executive order, the Defense Production Act of 1950, which he invoked in February to relieve Monsanto and producers of phosphorus of any liability associated with their production because of the war in Iran. In other words, these are petroleum products. We need these products to grow food, and therefore you are really impeding the ability of the food production sector, the farm sector, to grow food. You know, when that statement came out, the first thing I looked, you know, when Trump announced his executive order in February under the Defense Production Act and said we're going to create an immunity for producers of glyphosate and phosphorus because these are inputs that are essential to food production. We can't grow food without them. The first thing I did was I went to the underlying document and looked to see what the justification was for that. Do you know there was not one finding? There was not one citation. This was a blanket statement made without any justification. And here we have a Supreme Court case that's supposed to be providing facts to a court of law, the highest court in the land. And they quote President Trump, which is a statement that is ludicrous. And thankfully, we had an amicus brief here from farmers. The farm community submitted its own brief. And in that brief, they went through the alternatives to glyphosate. They had citations on how we can grow food organically without the use of these chemicals. And so the justification for why we care so much about this chemical in the first place, again, which is really not what this case is about. That's not a matter of law. That's a matter of policy. But nevertheless, it's sort of hanging over this case. And you know where it's really an effective argument for Monsanto? In the states. when they go to the state legislatures, they bring in the Farm Bureau, they bring in all these chemical intensive farmers, and they say to local, state elected officials and local officials, you're going to destroy your food production system. You're going to destroy the farm economy
And the
in this
farmers
farm
all say,
state
that's right.
without this chemical.
Right.
And again, no justification and no discussion of all the harm that the chemical is causing, not only to consumers here or people that are affected by drift off of agricultural sites, but farm communities, farm families, and farm workers. And it shows that, we have a court system made up of people that are really not experts. And the sad thing here is that they were informed. This Supreme Court was informed by 17 amicus briefs with incredible expertise. Not one justice referred to any of those briefs. And our public health, our family's health, our cancer is tied to these decisions. It's very frightening and it's outrageous. We have this discussion every day in our office when we read yet another study that EPA has not taken into account on adverse impacts on health and the environment. We say, look, the only solution here is to shift our production system to organic because, what will it take? You guys track the regulatory system. You delve into the deficiencies, the limitations of the regulatory system, and then you come up with, well, we need to improve. We all come up with suggestions for improving, or we write comments on how the agency should use its statutory authority to restrict a chemical. And then, of course, we look at the final outcome and no. And then we go to Congress and we say, look, we really need to improve this law because we're not adequately protecting health and safety. And Congress says, well, it's going to hurt farmers or whatever they say. And so, I've been at this, you have been 40 years, right? And so we're looking at a system that has failed us. We're looking at a regulatory system that's being further dismantled, as you said. And so we're in a situation where, as families, as parents, as responsible community members, we have to ask ourselves, if that system is so flawed, if the Supreme Court refuses to delve into the intricacies of what's going on in our food production system and how that's adversely affecting our health, we as consumers need to find the organic system in our food stores, which is available to us through the USDA certified organic label, and prop that system up, build it up, protect it against the Monsantos of the world that want to degrade that system, and build the agricultural economy as an organic system in the interest of the public's health and environmental protection. That's what we need to do.
Jay Feldman, Executive Director of the nonprofit Beyond Pesticides and a leader in the organic food movement. You can learn more about Jay and his organization at beyondpesticides.org. That's going to do it for our show today. Don't forget you can find links to all the things we talked about today on our program website, greenstreetnews.org. And you'll also find a link to our new YouTube channel, Green Street with Patty and Doug Wood. We hope you'll subscribe. Patty and I'll be back next week with another edition of the show. Thanks for listening.